Hi everyone, I am Alfonso Saban and I'm a partner at Herrero and Asociados. Today we're going to be talking about trademark oppositions in Spain and go through some specifics which will help foreign practitioners. As in other European Union countries, oppositions in Spain can be based upon a number of grounds, such as applications and registrations of trademarks, commercial names, geographical indications, company names, copyright creations, and non-registered well-known trademarks. Remember to choose a solid base for your opposition at the early phase, as these may not be modified later throughout the proceedings. For all common law practitioners watching me right now, remember that non-registered, non-famous trademarks do not grant their owners any solid base to act against infringing applications. If you're not 100% sure that you can successfully prove your trademark's well-known status in Spain, it is imperative that you apply for it as soon as possible. Back to our opposition proceedings. It is fair to say that these are eminently written and very streamlined. And while the opponent sort of has an indirect chance to file further arguments together with the evidence of use against a writ of arguments, there are no oral hearings or discovery phases after that. So you need to pull out all the stops with your writ of arguments. You can generally expect a decision in less than 6 months. If unfavorable, you may appeal said decision before the office and later before the civil courts. Unlike countries like the United States, Mexico, or Argentina, where use plays a relevant role to either get and or renew registrations, owners do not need to prove use to obtain and maintain the registrations, neither before the UIPO nor before the Spanish office. However, when opposing a new application based on registration which is 5+ years old, the applicant may request proof of use, and the opponent will need to submit it, or else the case will be dismissed. There are 4 main things you need to keep in mind regarding time, space, language, and substance. Time, evidence of use will need to belong to each of the last 5 years. Space, relevant territory will be Spain, unless the mark upon which the opposition is based is an EU one, in which case the relevant territory will be the EU, and may not necessarily include Spain actually. Language, only evidence in an official language in Spain, usually Spanish, will be accepted. Substance, the Spanish office has proven to be much pickier than the UIPO. You need to try your best to submit evidence encompassing each and every class and as many goods and services relevant for the case as possible. It is a pain in the neck, but it is what it is. While perhaps not too exciting or open for improvisation, the Spanish trademark opposition system is a cost-effective one and succeeds in issuing decisions in very reasonable timelines. I hope these introductory insights were helpful and remain at your full disposal for any questions you may have. Have a good one.